It is important to note here and say again that they are the only people who have heard and examined every witness and every piece of evidence. They discussed and debated the evidence among themselves before arriving at their collective decision. After their exhaustive review of the evidence, the grand jury deliberated over 2 days, making their final decision. They determined that no probable cause exists to file any charge against Officer Wilson and returned a no true bill on each of the 5 indictments.
One grand juror in the Darren Wilson case is now suing St. Louis County Prosecutor Bob McCulloch. The juror, referred to as Grand Juror Doe in court documents, wants the legal right to speak about the grand jury case against former Ferguson police officer Darren Wilson in the shooting death of the unarmed 18-year-old Michael Brown. And what the juror says are mischaracterizations by District Attorney Bob McCulloch. In the complaint filed today in federal court, Grand Juror Doe says, from plaintiff's perspective, defendant's statement characterizes the views of the grand jurors collectively toward the evidence, witnesses, and the law in a manner that does not comport with plaintiff's own opinions. Plaintiff also wishes to express opinions about whether the release of records has truly provided transparency. Plaintiff's impression that evidence was presented differently than in other cases, with the insinuation that Brown, not Wilson, was the wrongdoer, and questions about whether the grand jury was clearly counseled on the law. According to current Missouri law, a grand juror could be imprisoned for up to a year for talking about a grand jury proceeding. Joining me now is Tony Rothert, an attorney representing the grand juror and the legal director for the Missouri ACLU, and Liz Brown, a columnist for the St. Louis American and a criminal defense attorney. Tony Rothert, in the grand jury, do we know whether the grand jury finding in that case was unanimous?
We don't know. What the prosecuting attorney told us is that a collective decision was reached, and that is something that this grand juror would like to be able to talk about. You know, a little more nuance than what the prosecuting attorney has given as the official line.
Well, you only needed 9 of the 12 grand jurors to agree on a course of action, and so to get the no true bill, that means there could have been possibly as many as 3 grand jurors who did want to indict on something. Isn't that correct?
Well, no, actually, you needed 9 to get an indictment. So if there were 8 for an indictment, there would still be no true bill if it was 8-4 or 7-5. So we don't know what the vote is. The impression that's been given by the prosecuting attorney is that it was a collective decision by the grand jury, and this grand juror would like to talk about that amongst other things.
Liz Brown, it seems that since in many ways this particular grand jury did not follow standard form in Missouri, allowing this grand juror to speak would just be one additional unusual component.
That's correct, but you also have to look at what has driven, presumably driven this grand juror to want to speak out on it. The things that the ACLU presented in their lawsuit were extraordinary. When a grand juror is basically saying that the prosecutor is mischaracterizing what happened, he's being dishonest about what happened, that's huge. When a grand juror says that the victim in the case, Mike Brown, was the defendant and the defendant was the victim in the way that it was presented, it's remarkable. When a grand juror says, I have seen this grand jury go prosecute hundreds of cases, and this case, the Darren Wilson case, was different than any other case that I've experienced, that's huge. That's different, and if it's different now, it's born out of what Bob McCulloch has done to drive this different result and these different actions on the part of his office.
Tony Rothert, in your representation of this grand jury in federal court in this case, the judge will be interested in what precedent you might be able to cite that would allow a grand juror to speak in a situation like this. What might you offer the judge by way of precedent?
Well, you know, this is really an unprecedented case. There are cases, there's a U.S. Supreme Court case about witnesses in a grand jury being able to talk, but there aren't cases where a grand juror has asked to speak. And usually there are very good reasons for grand jury secrecy. This is an unusual case in that the prosecutor has says he's released all the evidence, has said what the grand jurors thought about the evidence, and has purported to release everything. So the usual reasons for grand jury secrecy just aren't there. And in fact, the only people who can comment on what the prosecutor has said, what the government has said happened, would be criminals if they talked about it.
And Liz Brown, one of the points that Tony Rothert's lawsuit, as they've written it, brings up is that the incorrect instructions to the jury, legal instructions to the jury, the grand jury in this proceeding, which were then sort of corrected toward the end of the process, something that I covered in depth on this program. And that is, again, one of the unprecedented aspects of this case.
And one of the things that the grand juror will be able to add to that are things that don't make it to the transcript. Things like tone, things like timing, things like aggressiveness, whether Kathy Elizadeh questioned Darren Wilson in a way that was kind and gentle and patient and loving even. Whereas if the way that she questioned another juror was completely different. That's what this grand juror will be able to say. And the remarkable part about this, the optics of this can lead to an extraordinary circumstance. Consider this: if this grand juror is not allowed to come forward and the grand juror decides to come forward anyway, then Bob McCulloch would be in the position of having to bring charges against this grand juror. And if this grand juror is African American, he would be in position of bringing charges against an African American, charging them with the crime. Whereas witness number 40, a white witness, he has declined. Bob McCulloch has declined to charge that witness with perjury. A witness that was known to law enforcement as a perjurer, a witness that came in and testified twice, bringing documents with their fabricated documents to almost double down on her dishonesty. But Bob McCulloch says, I am not going to pursue perjury charges against her. So that would be the position that Bob McCulloch is in if the court does not allow this grand juror to come forward and tell their tale.
Tony Rothert, is the grand jury you're representing in this case African American?
You know, we shouldn't make any assumptions about race or gender, and we're not revealing who the grand juror is for that person's own legal protection at this point, including any information.
Just to get it technically correct, Tony, at this point, is there any legal restriction on you or on your client on revealing just the name and identifying characteristics about the grand juror?
Well, this grand juror is concerned and is afraid of coming forward without the ability to speak.
I understand that, but I'm just asking about actual legal process in Missouri. Is there anything that makes it impossible for a grand juror to reveal the simple declarative sentence, I was a grand juror on that case?
Yeah, we think that if you read the law strictly, that would be illegal, just revealing that you were a member of the grand jury.
Okay. Tony Rothert, thank you very much for joining us, and Liz Brown, thank you for joining us tonight, too.
Thank you.
Coming up, how one judge in Detroit is sentencing young men and women in a new and different way. And later, remembering ESPN's Stuart Scott.